For now, let's take you to KwaZulu-Natal. The Durban Magistrate Court, of course, hearing the bail application of two suspects who are implicated in the murder of Kiernan, aka Forbes, and Tebello Tibz Motsoane. Their bail bid is now underway. Let's listen in.
The matter involving 5 accused appeared in Durban Magistrate Court on 29 November and has been postponed to the 7th February 2024 for the state to serve indictments on the accused. There were several oppositions by those representing all the accused, including both applicants, to the matter being postponed for a lengthy period during this court appearance. The assorted judgment by Masuku J attached to the papers filed in this application was also a subject of those proceedings. Reference to this appearance becomes relevant in this application because both applicants rely thereto. 7. My team and I have been given a notice of motion relating to bail application on new facts and affidavits by both applicants upon which this application is based. We have read the said affidavits and wish to respond as indicated here in answer. B. Meaning of new facts. 8. I have been advised that there is no definition of new facts as indicated in Section 65, subsection 2 of the Criminal Procedure Act 51 of 1977. I have been further advised that case law, however, provides at least 5 guidelines and principles which are of assistance. The following is indicated. 8.1. New facts are facts that came to light after the refusal of bail and circumstances which have changed since the successful bail application was launched. 8.2. New facts must be sufficiently different in character from the facts presented at the alien successful bail application and must not simply constitute a reshuffling of old evidence of facts. 8.3. The alleged new facts must be relevant for the purpose of the new bail application. 8.4. In determining whether facts are new or not, the court is inevitably required to have due regard to the evidence presented or information received at the earlier unsuccessful applications. 8.5. In a situation where evidence was known and available to bail applicant but not presented by him or her at the time of his or her earlier application, such evidence cannot, for purposes of a renewed bail application, be relied upon as new fact. The bail applicant must not be permitted to seek bail on several successive occasions by relying on a piecemeal preservation of evidence. 9. I have been advised that further submissions will be made in court and the case law upon which above principles and guidelines are based will either be court. 10. And the response to both applicants affidavits submitted in this court, I'm guided by these guidelines and principles. I now turn to deal with the alleged defects as indicated in the applicant's affidavits. I propose to deal with each applicant individually or separately. In this exercise, I will deal with applicant 1, Wabeni first, and applicant 2, Lidobuken demanded subsequently. C. New facts. Applicant 1, Ms. Wetemba A.V. Wabeni. At paragraph 3.4.1 of applicant's affidavit, no fear of interference with the witnesses. Paragraph 11. As indicated in my initial affidavit, Exhibit G, in general and paragraphs 232 to 235 in particular, this issue remains a concern to the state. It does not mean that because the investigations are completed, the witnesses will not be approached or threatened in the minimal or eliminated in the extreme. In fact, once the docket copies are disclosed, there will be more reasons to have witnesses' well-being or safety taken care of. The well-being and the safety of the witnesses in this matter remains a great concern until such time that this matter is finalized. At paragraph 3.4.2 of Masuku J judgment in Eswatini 12. As earlier indicated, as part of the objection to a lengthy postponement, both applicants and their co on this very judgment. The proceedings on the 29th November 2024 had to stand down to await the said judgment. This Honorable Court was informed of this judgment and taking into account the matter was postponed to the 7th of February 2025 to allow the state to serve the indictments on the applicants and their co-accused. 13. Applicant is asking this Honorable Court to again consider the same fact as it did on the court appearance on the 29th of November 2024. We are of the view that this serves as a repetition or a cycling of the same facts this Honorable Court has ruled on, and this is undesirable. 14. Further, the state indicated on the 29th of November 2024 that it will proceed with the trial with the matter against all 5 accused as things currently stand. This aspect, therefore, is not a new fact, as this was dealt with in the initial bill application and again confirmed in court during the appearance of 5 accused on the 29th of November 2024. Annexures NF2 and NF4, paragraph 15. This fact was raised by the applicant during the initial unsuccessful bill application. The reference is made to paragraph 58 of Exhibit F. This Honorable Court, therefore, did consider this in the initial bill application. It cannot be said to be a new fact in this regard if same was raised in the initial unsuccessful application. 16. Further, according to Annexure NF2, the applicant himself gave an undertaking to the school that he will, despite him being in custody, be able to pay the fees. On reading of the second paragraph of Annexure NF2, the applicant requested an extension and gave an undertaking to have fees settled by the end of January 2025. He will therefore pay the fees and his incarceration will not affect that. 17. Further, from the reading of Annexure NF4, school fee statement, the family managed, despite his incarceration, to pay the fees at Grace Place. There are some noticeable differences in the annexures filed March or April 2024 by the applicant in the initial bill application and the present application filed in December 2024. Of note is the following. 17.1. According to Annexure HG5 of Exhibit F, in the initial bill application, the school fees is reflected as 2,992 rands, whereas on Annexure NF is reflected as 3,200 rands. 17.2. According to Annexure HG5 of Exhibit F, the total paid in February 2024 is the amount of 16,322 rands. Whereas on Annexure NF4, the total amount paid in February is 12,000 rands. 17.3. According to Annexure HG5 of Exhibit F, the total amount paid in March 2024 is 00, whereas on Annexure NF4, it reflects that total amount paid in March 2024 is 10,000 rands. Paragraph 18. The sub-differences of the school fees statement relating to the same individual for the same school year brings down the credibility of the documents filed by the applicant. My team and I made attempts to verify this information and other with the institutions concerned. However, same are still closed for school holidays. 19. He has not indicated in his present papers as to how he intends to honor such a commitment. It does, however, remain a commitment he made to the school which he intends to keep if he is to be believed. If he made this commitment to the school with no intention to honor it, how can this Honorable Court accept his word should there be a consideration to grant his bail? Annexure NF3, paragraph 20. I am informed and advised that the new fact must be relevant for bail purposes. The letter, though not dated, not bearing any institutional stamp or letterhead, is indicated that Lutando mentioned therein was concerned about his mother dying. There is no mention of the applicant or his incarceration being the reason of Lutando attending counseling. Just a moment, Worship. As a president of Worship. There is no indication in the applicant's papers of the mother encountering some emotional problems which could have led to the child feeling the way he is. There is insufficient evidence or information in this regard. Paragraph 21. Firstly, there is no indication at all how this is relevant for the purposes of bail application on new facts. What is the connection between the refusal of bail and the emotional concerns of the child? The presence or otherwise of the applicant at home does not seem to have triggered those emotions. The applicant himself has not indicated how this fact is relevant to his renewed bail application. Paragraph 22. Secondly, the child has successfully attended counseling and no longer attending because it appears he is now coping as indicated on penultimate paragraph of Annex NF3. Paragraph 23. We are of the view that this new fact is not relevant for the purposes of renewed bail application. Even if the court finds that it is relevant, it is not sufficient for this honorable court to grant bail because, as the letter suggests, the child now is fine and coping. There is a further room open for the child to seek further counseling should the need arise. Your Worship, just before I proceed, I was told by my learned colleagues that I mentioned the name of the child on the report. Yes, if maybe the court, Your Worship, can also advise the media houses not to write the name of the child on their papers.
It's in the best interest of the child that the child's identity should not be disclosed
in these proceedings nor in the media. So I'm appealing to you officers of the court not to mention the names of the children as well as to the ladies and gentlemen of the media not to publish the names of the children, please.
As the President for 24. Annex NF5. Paragraph 24. On the reading of Annex NF5, it appears that Precious Gwabe. On the reading of Annex NF5, it appears that the mentioned person attended a debriefing session on the 4th of March 2024 due to a traumatic incident that happened at home. It seems to be a patient in the confirmation letter. She is one of the wives of the applicant. 25. The letter, though dated 26th November, year 2024, indicates that the debriefing was a session which was attended by the same person on the 4th of March 2024. This information was therefore available as on March 2024 and as when she attended the session. As of 4 March as when she attended the session, this information therefore was available to the applicant at the time of the initial unsuccessful bail application. 26. Applicant filed on a founding affidavit Exhibit F dated 19 March 2024 and subsequent to that a supplementary or replying affidavit Exhibit M in his initial unsuccessful bail application. There is no mention of this issue in any of those affidavits, even though the wife attended the session prior to the bail affidavits being filed in court. At the time Exhibit F was signed on 19 March 2024, the applicant knew of this issue and decided not to raise it with the court. 27. It cannot be said that he was unaware of this information because his wives attended most, if not all, the court proceedings during the bail application. The name of the person mentioned on this affidavit filed a supporting affidavit to Exhibit F dated 16 March 2024, which date is after her attendance session. She did not mention this aspect in the said supporting affidavit. Further, she filed another affidavit, Exhibit M, dated April 2024, which date is also after the debriefing session, and once more this issue is not raised by her. 28. In a situation where evidence was known and available to a bail applicant but not presented by him or her at the time of his or her earlier application, such evidence cannot for the purposes of a new bail application be relied upon as a new fact. The bail applicant must not be permitted to seek bail on several successive occasions by relying on the piecemeal presentation of evidence. 29. Information mentioned on Annexure NF5, there was no paragraph 29. Information mentioned on Annexure NF5 therefore was known and available to the applicant at the time of the initial bail application and cannot be relied upon in this renewed bail application. It is not a new fact for these peoples. At paragraph 3.4.7 to 4.4, paragraph 8. Further raised in the mentioned paragraphs were mentioned in the applicant's affidavit submitted in the initial unsuccessful bail application. The matter being in the district court was extensively dealt with on 29 November 2024 and has been postponed for indictment for Peoples and Will on the 7th of February 2025, transferred to the High Court. 31. This honorable court is further referred to paragraph 58 of Exhibit F in relation to what is raised on paragraph 4.1 to 4.2. Applicant further raised this issue on paragraph 32 of his replying affidavit. At paragraph 4.3, state has no strong case. 32. Mention should be made of the fact that the state has now secured a CCTV footage at the King Shaka Airport for the day of the incident when the deceased, Mr. Forbes, arrived at the airport, and the following is clearly noted therein. 32.1. Mr. Forbes is seen arriving at the airport at around 1400 hours 47 minutes, walking out of the arrival terminal towards the parking lot where his entourage was awaiting him. As he joins them, they were all walking towards the car rental area. 32.2. Applicant or accused 4 has just arrived at the airport at the time the deceased Mr. Forbes was walking towards the area whose entourage was waiting for him. 32.3. Whilst walking as they joined each other, applicant Wadeni follows them in a short distance, walking behind them with a limp. He is wearing a white and black top with long sleeves and a navy short pants. He is wearing pushing shoes. 32.4. As the applicant is following the deceased and his entourage, he is on call on his cellular phone. We established that the third call was to accused number 2, Zenzelen Demand. This piece of evidence, viewed with other evidence already outlined in court, is indicative of the communication between those that planned and executed the murders. 32.6. My apologies. 32.5. He followed them up to the car high offices to a distance of a few meters closer to them. He was there for a short period of time and left them while still on the phone. 32.6. As indicated in my initial affidavit, the applicant or accused followed the deceased from the airport to the hotel. He left the airport almost at the same time as the deceased Mr. Forbes. 32.7. Applicant or accused can be seen inside the BMW as earlier indicated. The same clothing is seen wearing inside the airport can be seen inside the BMW. and he is the driver thereof. Further, as he drove past the hotel where the deceased and his entourage entered, he made another call to accused to Zenzele Ndimane. 32.9. There is further credible evidence putting the applicant or accused for at the airport and following the movements of the deceased on the day of the incident. At paragraph 4.4, a release on bail will afford an opportunity to raise fees and consult. The applicant managed while in custody to prepare and bring an acceptable bail application, and he was legally represented by two experienced counsel and at times by his attorney. He managed also to prepare and bring his bail appeal to the Durban High Court, which appeal was unsuccessful. 34. This is not a new fact and was considered by this honorable court in the initial bail application. 35. The alleged new facts submitted by applicant are not new facts, as this honorable court dealt with the same before and do not, in the interest of justice, justify the release of the applicant in bail. 36. Applicant is raising same facts and not different in character, but the reshuffling of the old facts that he raised in his initial unsuccessful bail application. There are therefore no new facts proving the existence of exceptional circumstances justifying the release of the bail applicant in bail. Bail should be refused and application dismissed. Applicant 2, Lindo Ndimane. At paragraph 3.4.1 to paragraph 3.3.4.2, paragraph 37. These paragraphs are similar in nature to what is raised by applicant 1. I refer this honorable court to my paragraphs 11, 14 here in above. At paragraph 3.4.3 to paragraph 3.4.4 and annexure LL7. Paragraph 38. Applicant 2 indicated in his initial bail affidavit, paragraph 7, exhibit E, that he is a shareholder on a poultry farm and he earns an amount of 70,000 rands per month from this entity. 39. In this renewed bail application, the applicant has not raised any challenges relating to this poultry farming, and therefore it cannot be accepted. It can be accepted that it is well. With a salary of about 70,000 rands, it can be accepted that he is able to cater for his family. Paragraph 40. As a new fact, he has raised the issue of a damaged taxi. In paragraph 8 of Exhibit E, he indicated that he was generating an amount of 20,000 rands from this taxi. This amount is far less compared to his earnings from a poultry farm. 41. He is not the only person that is giving financial support to his mothers. His brothers are also giving the same. His brother is also giving the same support. 42. The applicant did not, in his initial bail application affidavits, give detail of how he is supporting his father's wives. Neither is he giving such detail in the present application. He has not given any detail of how the damage taxi has impacted on this. The facts are simply insufficient for consideration in this honorable court. 43. It is not clear how applicants suffered extreme financial loss from the damage taxi. The said taxi contributed about 18% of his monthly income if combined with the income from the poultry farm. This percentage cannot be said to be extreme in the financial circumstances. 44. There were no clear employment duties explained by the applicant in his initial bail application affidavit. There was no mention at all as to what those duties were, except to indicate that he owns a taxi that operated under Maluka's Taxi Association and him having shares in the poultry farm. 45. This honorable court is now expected to speculate what those duties are that he has now not been able to conduct. There was and is still insufficient evidence for this honorable court to consider. 46. On the 6th of January 2025, my team and I followed up upon information as per Annexure LL7, and the following is reported thereto. 46.1. My team proceeded to the area of Camperdown where the applicant's residence is situated. Team contacted applicant's uncle, and he was informed that the said vehicle was in Durban area for repairs. 46.2. Team was later informed that the said vehicle is at a demanding residence in Umkomazi. This place belongs to the brother of accused 2, Zenzelen Duman. The team attended the said residence and found the said vehicle in an open spaces opposed to the place on the photos as per Annexure LL7. Photos were taken as of how vehicle was found. I attached the said photos as Annexure PK of how the said vehicle was found as of the 6th of January 2025. 46.3. Mr. as mentioned here in this affidavit, indicated that the vehicle was involved in an accident on 18 May 2024 around the Ispingo area, and the accident was not reported to the police. Police did attend the accident scene, but as there were no injuries, they left the scene. 46.4. The vehicle appears to be abandoned as it was found in an open space or fell to some distance away from the houses. 47. The state of the vehicle as found does not indicate that there is some work done on it to fix it. It has been about 7 months since it was involved in an accident as reported by the applicant's brother. 48. It remains unclear as to why the applicant has not fixed the vehicle despite having an income of about 70,000 per month. It also remains unclear as to how he will be able to do so only if granted bail, whereas it is something he could arrange to be done while still in custody. Is the fixing of the said vehicle a priority if one must consider that it supposedly brings some needed financial support to the family? At paragraph 3.4.5, matter not transferred to the High Court. 49. The matter, being that the District Court was extensively dealt with on the 29th of November 2024 and has been postponed for indictment purposes and will on the 7th of February 2025 be transferred to the High Court. And further factors to be considered. 50. The fact that he supports his family and his late father's wife was read on paragraph 18.24 of Exhibit E. It is not a new fact, as this honorable court was informed of same in the initial unsuccessful bill application. 51. On paragraph 18.3 of Exhibit E, the applicant did indicate that his detention is an anticipatory punishment, as the state does not have evidence to sustain the charges. This is therefore not a new fact. This honorable court dealt with this fact. 52. On paragraph 18.7 of Exhibit E, the applicant mentioned the fact that his release on bail will enable him to raise money for the services of his legal representative. He mentioned the same in his paragraph 4.3 in the present application. This honorable court was made aware of this fact in the initial bail application, and it is therefore not a new fact. 53. Further, the applicant is managed while in custody to bring an extensive bail application that this honorable court dealt with. He has been able to prepare for same. 54. The alleged new facts submitted by applicant are not new facts, as this honorable court dealt with same before and do not, in the interest of justice, justify the release of the bail of the applicant bail. 55. Applicant is raising same facts and not different in character, but the shuffling of the old facts that he raised in his initial unsuccessful bail application. There are therefore no new facts proving the existence of exceptional circumstances justifying the release of the bail applicant on bail. Bail should be refused and application dismissed. At conclusion, 56. Both applicants failed to establish that there are exceptional circumstances justifying their release on bail. The new facts raised are neither new nor are they sufficient to establish the existence of exceptional circumstances justifying their release on bail. 57. The state's case is prima facie strong against both applicants, and the risk factors mentioned in Section 64, Section 6, subsection 4 of the Criminal Procedure Act 51 of 1977 exist to justify the refusal of the applicant's release on bail. 58. Bail should therefore be refused. It is signed, Your Worship, by Warrant Officer Kiernan. For the record purposes, Your Worship, we also have annexed...
And there you have it. That is essentially the punchline from the state. Bail should be refused. And that's because 2 of the 5 men who've been arrested in connection with the killing of AKA and Tibz are making a new bail bid today. In fact, they are presenting this on the basis of new apparent facts. And the state, quite frankly, not convinced that the facts are either relevant or that the information is in fact new. Part of what's been stated there by the accused is, for example, the condition of their children whilst they're inside prison. The state saying that even if this were a relevant fact, it's not sufficient because there are other people looking after their children whilst they're in jail. They've also raised issues around raising fees and the ability to consult with their lawyers. Another matter that's come out amongst a long list, by the way, is accused number 2 saying that he is in fact responsible for supporting his father's wives. The state saying, in fact, that he's not the only source of income for these individuals. And in fact, it seems, I think some of his siblings are involved in that in any case. So we'll get a sense of what this court decides. You might remember that in a completely separate but related matter, 2 brothers are also challenging the conditions under their extradition from Eswatini to join the 5 people in total who are currently on trial in relation to AKA's murder back in February, of 2023.